The courts are too quick to push contact onwards, and we're going to do a separate episode about why that is. Why do the courts order contact in spite of the fact that there's been domestic abuse? Hello and welcome to this episode for the Survivor Diaries. This episode is looking at what is going wrong with children proceedings and domestic abuse, and this is, in my humble opinion, as a practising professional. I'm a lawyer in England and Wales, family law, and I practice predominantly in child arrangements proceedings in private law. So that's usually between the parents, and usually in the cases that I deal with, there are allegations of domestic abuse, either because domestic abuse is there or because the allegations are false, which can happen as well. So in this video, this is a very short video about what is going wrong with the family justice system, and in particular with children and domestic abuse proceedings. First of all, before we get into that, I'm just going to do some disclaimers, as I do at the beginning of every video. So I am, as I mentioned, a family lawyer in England and Wales. So if you live outside of England and Wales, this law is not likely to apply to you, the actual law. The aspects of domestic abuse, I imagine, are a global problem the world over, and the same kind of problems would arise. However, this is the legal jurisdiction that I'm talking about, England and Wales. Secondly, I'm only giving very general advice, if I am giving advice at all in these videos, and it's important to always take specific legal advice about your own unique situation, all situations being unique. Finally, as I disclaim in all videos, I am talking about domestic abuse as a gender-based issue. So it is a gender issue, it's domestic abuse, and I am talking about it as an overhang from the patriarchal system. I know from some other videos that we've had recently that there is some criticism about that approach, and that is something that I intend to deal with in amongst this series of very short recordings that I'm doing now. So this particular recording, we're looking at what's going wrong with the children proceedings and domestic abuse in the family justice system in England and Wales. So the first question to ask is there something wrong? Yes, clearly there is something wrong, and I'm saying this as a family solicitor. There are huge criticisms of the family justice system, both from very polar ends of different spectrums of things that you might find within children proceedings. So ranging and associated with the allegations of domestic abuse, there's a huge wave of complaint, mainly from mothers, and I am being gender specific, mainly from mothers saying that domestic abuse allegations are not being listened to or looked at properly by the court, and that contact at all costs is being forced to happen with an abusive personality. On the other end of the spectrum, you have groups of people, and I am going to be gender specific and say that this is a lot of fathers who are saying domestic abuse allegations have been wrongly used against them and prevented them from having a relationship with their children. Both of these polar opposites indicate that there is something perceived to be completely not right about the family justice system. Another thing that tells us that the family justice system in handling private children law proceedings and domestic abuse cases, the problem that seems to be coming up, as has been pointed out by Sir Andrew McFarlane, is the volume of cases that's coming through the family justice system. And my view is that this is the same case that's repeating over and over again. And it's very common amongst people that I've spoken to, for particularly where there's domestic abuse allegations, for a children case to be returning to court and returning to court and returning to court again and again. And my view is that the court are failing to deal with the domestic abuse the first time that it actually comes to court. And this is the problem. People who watch my videos will know that I say that the domestic abuse will continue through the child arrangements unless it's been addressed by the perpetrator. So we've covered that there is something wrong. So do the family justice system know that there's something wrong? Well, they certainly do, because there is a private law working group reviewing the child arrangements programme. And that is if you've seen our videos about child arrangements proceedings with and without domestic abuse, that is the formula that the courts will take, the stages of the proceedings that the courts will take in looking at child arrangements proceedings on their own and child arrangements proceedings where there are allegations of domestic abuse as well. The private law working group are looking at different ways that the child arrangements programme, so with its FUDRA, with its dispute resolution appointment in its final hearing and possibly with its fact-finding, which you'll know from the previous videos. They're looking at the structure and the process of going through those arrangements, the child arrangements programme. And that is what they are reviewing, and they are suggesting potential alternatives. But also, as you know from previous videos, you'll know that the private law working group are not looking at something which is the practice direction. So when the courts are looking at child arrangements proceedings and when there has been domestic abuse, they use the child arrangements programme as has been set out from the Children and Families Act of 2014. These stages of hearings and all this sort of stuff, and then alongside it, the court should be mindful. They must be considering as well a practice direction which tells the courts how they have to act in a certain situation, and court professionals how they have to act in a certain situation. Practice Direction 12J is the practice direction that sets out what the courts must do whenever domestic abuse is alleged. And the private law working group has said already, as we've covered, that the operation and the review of the Practice Direction 12J is out with their remits, i.e. they're not looking at it. But one thing that they did say in amongst this halfway review that they did was that they took this opportunity to, and watch these words, forcibly remind the court of the seriousness with which it needs to consider domestic abuse in its widest sense whenever it's alleged. So there's three terms there that are coming up which I think are very significant in the question of, is something going wrong in the family justice system with children and domestic abuse proceedings, and what is being done about it. So in what's going wrong, we've got the practice direction. The private law working group have said that the courts need to be forcibly reminded of the seriousness with which it needs to consider domestic abuse in its widest sense. So the seriousness of the issue of domestic abuse, when it's continuing between the co-parents, the co-parent who is recipient of the abuse is going through some kind of ongoing torture. Having to communicate with a co-parent who is abusive means that we have all of the changes to the arrangements. It's a continual mechanism by way communicating between the co-parents. It's open to one party putting the other one down, diminishing the other, openly slagging the other person off in the messages and through the children. This is how it continues. Domestic abuse continues in any way that it can. So if it's that the parties are separating and there's divorce, then it will continue through the arrangements for the finances or the orders for the finances. The domestic abuse will continue. In the same way, it will continue through the arrangements for the children, court arguments about the children, etc. There's a clear indication from the private law working group that the effects of domestic abuse are serious. On young people, they can have a devastating effect. So for a child, the trauma, the ongoing trauma of having to listen to or be a part of conflict as it's occurring can have serious impact on their development. So it's developmental trauma that can occur with children because they're not being able to be just children. They're having to find themselves pulled between the parents, the abusive parent quite often putting down the non-abusive parent, and that causing distress to the child. It stops them from focusing in schools, it stops them from focusing with their social development, etc., etc. So you can see that it's a serious problem. And in its widest sense, the courts need to look at domestic abuse in its widest sense. So what does that mean? Well, that means the definition of domestic abuse as set out at paragraph 3 of Practice Direction 12J. And that includes harm by, for example, seeing or hearing the ill treatment of another. This is one of the common ways, in my experience as a family lawyer, that children are harmed by ongoing domestic abuse continuing through the child arrangements. And that's hearing their other parent bad-mouthed by the abusive parent, and it causes this conflict for them. If that parent doesn't like that aspect of the other parent, and I'm both my parents, then maybe that parent, the abusive parent, doesn't like that half of me, and more, because they feel conflicted, because they love both of their parents, etc., etc. It can have an incredibly damaging effect. So within the court system, a failure to recognise those more subtle forms of domestic abuse, the court may just dismiss it as like, oh, well, one parent's saying bad things about the other and the other one's being sensitive. That's not okay. That's not all right, because continuing right through a child's life, that's going to have a very damaging effect. So I think here's where the courts make a mistake. They do not, or they dismiss domestic abuse because there's a need to process the case as quickly as possible. Look at all these volume of cases coming through. We want the parties to agree because that's a more stable order. If it's been reached by agreement, that's more likely to continue after the proceedings. So the courts try and push for agreement, and especially they try and push for agreement over contact at a very early stage in the proceedings. The reason they do that, and if an abusive father has representation, one of the things that they will be referring to is section 1 brackets subsection 2A of the Children Act, which is where this contact at all costs comes from. This is where it's set out in the Children Act of 1989 as amended, so that it now says at section 1.2a that the court should assume that the involvement of both parents in a child's life is beneficial. However, at 1.6 of the Children Act, you'll see that that is actually qualified by the fact that it's assumed that that child is not being harmed by the parent that they're talking about, which of course they are in domestic abuse. Practice Direction 12J has been recently amended. It now includes paragraph 7, which reinforces section 1 subsection 6 of the Children Act by saying that if there's been domestic abuse, the court is allowed to disapply that presumption at section 1.2a of the Children Act. And that, in my view, is where the courts are going wrong. The courts are too quick to push contact onwards, and we're going to do a separate episode about why that is. Why do the courts order contact in spite of the fact that there's been domestic abuse? We're going to do that in a separate episode. The purpose of this brief episode was just to cover what is going wrong with children proceedings when there's been domestic abuse allegations, and my view, which is my own personal view as well as my professional view from the cases that I see, and speaking very generally, which is lack of understanding about domestic abuse, lack of understanding of the harmful effects of these more subtle things that you see in ongoing domestic abuse. So the courts don't understand that so well. CAFCAS officers, there's an inconsistency here in the application of the practice direction, understanding about domestic abuse. It's by judges and magistrates, so sometimes I believe the same facts of the same similar cases can be dealt with completely differently by the courts because there's this lack of understanding of domestic abuse. The same applies CAFCAS, Court Advisory Service. Some CAFCAS officers very, very fluent in domestic abuse, just like some district judges and magistrates, and others not so much. They're still working on the contact at all costs with the earlier presumption before the changes to the practice direction, and that's where that becomes a problem. That's where that's not working in the family justice system. Because of this, perhaps you've then got an inconsistent approach in advice to people who are approaching the child arrangements programme when there's been domestic abuse, with some people even reporting that they've been told not to mention the domestic abuse because it will go against them. And this is something that I'm going to lead on to again in a further episode that we're covering, a very brief episode responding to, or a follow-up if you like, to the allegations of parental alienation video. And this is because people shy away from making allegations of domestic abuse in case it goes against them. And we've had a recent news article in The Independent by Dr. Ariane Barnett. She's a university lecturer, which is basically saying exactly the same as what I'm observing, which is that some mothers are too frightened to raise domestic abuse because of this fear that they're going to be accused of alienating and not supporting contact with the abusive parent. Okay, so that's covering the different things that I think are going wrong with the family justice system, child arrangements and domestic abuse. In addition to that, we're going to do a video about why the court would order contact when there has been domestic abuse, and also we're going to be doing this follow-up to the allegations of parental alienation video. A video from quite a while ago, but it's attracted quite a few comments, so I'm looking forward to covering that as well. Okay, I hope that's been useful. Thank you for joining us in this brief episode for the Survivor Diaries, and I look forward to seeing you in the next episode and/or vlog. Thanks very much. Bye.